Yes, Lord Mance has drawn our attention to a review in the Telegraph of sculpting with light, but I hope that needn't obfuscate the current theory.
Should be a work of art. Lord, I'm going to come back to Henshire, if I may, in a moment, but I wanted first to say a little bit about registered design law and the history of it. In our case, Appendix 5 to our case set out the history of the exclusion from registrability of sculpture. And your lordships will see that works of sculpture were first protected, that your lordships been through all that. And then in the 1839 Act, no notice was taken in that Act of the possible parallel effects of sculpture copyright. But shortly afterwards, the 1842 Act excluded sculptures from registration as an industrial design. If you just briefly turn to that at tab 10. Sorry, volume 1 of tab 10. Tab 10 of volume 1. On page 1170, grant of copyright, and regard to any new and original design except for sculpture and other things within the provisions of the several acts. And then if you just get a glance at subsection 4, there's a reference to no person should be entitled to benefit this Act with regard to any design in respect of the application thereof to ornamenting any article of manufacture or any such substance, unless such design have, before publication thereof, been registered according to this Act. So they had to be novel. And then further down, there's a reference to the marking of the goods. And although it doesn't say so there, I think it was at that stage that the Victorian design system instituted little kite marks that you sometimes see on bits of Victorian china. Little kite mark with numbers and letters in it, which indicates the date and various other details of the registration, and enables you to look it up in the Designs Registry and find out who applied for it. But going back to the Appendix 5, the 1850 Copyright of Designs Act did permit designs to be registered, sculptures to be registered as designs, but only in a very special way. It preserved the distinction between sculptures and designs in that such registrations didn't need to be made prior to first publication. The term of such registrations was potentially longer, being for the remainder of any period under the Sculpture Copyright Act 1814, and the marking requirements were different. Instead of the familiar kite mark, registered sculptures merely had to be marked registered with the date of registration. And in fact, if your lordships look at that statute, tab 26 of volume 1, no, it's not tab 26, that's a mistake. Sorry, it's tab 7 of volume 1. You can see in section 6 on page 1247, there is this special provision for the registration of sculpture. And such registration, further down the section, be for the whole or any part of the term during which copyright in such sculpture may or shall exist under Sculpture Copyright Acts. Whenever such a registration will be made, the registrar shall certify it. And then on the next page, section 7 provides for some what were then pretty stringent penalties for infringing the copyright in the sculpture design. Section 7 on page 1248. £5, not exceeding £30 for the proprietor of the sculpture. Yeah, absolutely. And then at the bottom of that, shan't be entitled to the benefit of this Act unless every copy or cast of such sculpture which shall be published by him after such registration shall be marked with the word registered and with the date of registration. So, although sculpture was registrable under that Designs Act, it was actually a rather special kind of registration which gave very special privileges to the person who registered it. That was all repealed in 1883, going back to my appendix. The 1883 Act repealed and replaced earlier design legislation, provided for a 5-year exclusive right in registered designs, and once again the definition of design in section 60 ended with the words not being a design for a sculpture. And then section the Patents and Designs Act 1907 superseded that, again saying design means any design not being a design for sculpture. But then there was a hiatus starting in 1919. The 1919 definition of the registrable designs didn't exclude sculpture, and it remained not excluded until 1949, with the Popeye case coming in the middle, revealing that sculptors had been hard done by making sculptures registrable designs. And that was cured by Rule 26, which excluded sculptures from registrability in the 1949 rules. Though works of artistic craftsmanship were not excluded from that exception, or by that exception. So works of artistic craftsmanship were registrable designs, and always were. What I get from that is this, that sculpture, in my submission, was intended, and we saw it, of course, from the Gregory report later, sculpture was intended always to be protected as a fine art, something analogous to painting, writing and composing, as the Gregory report put it. And another indication of the differences between them is to be found in Appendix 4 to our case, where we set out the relevant periods available for various kinds of copyright and design protection. Even copyright started quite short under the Act of Anne, of 14 years plus 14 if the author was still alive. Then it went up a bit in 1814, though the sculpture period was 14 years. But the design term in 1839 was only 12 months. In 1842 it went up to potentially 36 months, but a lot less than 14 years. 1850 it went up to a potential 6 years, though as we've seen, so far as sculpture was concerned, you could have as much left as was left of the life of your sculpture copyright. So if you registered your sculpture shortly after you made it, then you'd get 14 years. 1883 limited the term of registered design to 5 years. And then for a very short time in 1907, the design period lasted for longer than the sculpture period. For just 4 years. The design term had evolved to 15 years. The old Sculpture Act still remained at 14 years, but that was put right in 1911 when the Imperial Copyright Act put it up to the familiar for many years period of life of author plus 50 years. And then the 1919 design term was 15 years, and that remained unchanged until 1988. So what we see from all that is a picture of the sculpture term being approximated to the conventional copyright period for writers, composers, and painters. Now, that's not to say that that long term didn't apply to all drawings, because it did. But in the context of three-dimensional works, I would submit that what we see from that is yet a further indication, as indeed Gregory saw it, that sculpture was being put on the same footing as fine arts, along with the works of painters, writers, and composers. And just to rub that in, it's worth seeing the way in which registrable design has been defined. Because although one sometimes thinks of registered designs as being essentially mundane things, even so, it was essential that they should have eye appeal. We get that, for example, from the 1919 Act, Section 19, which is in Bundle 1, Tab 20. Design means only the features of shape, configuration, pattern, or ornament applied to any article by an industrial process or means, whether manual, mechanical, chemical, separate or combined, which in the finished article appeal to and are judged solely by the eye, but doesn't include any mode or principle of construction or anything which is in substance a mere mechanical device. Those words, I should say, were based on earlier jurisprudence, which I won't trouble your lordships with. In the 1949 Act, at tab 22, Section 1.3 provides design means features of shape, configuration, pattern, or applied to an article by the industrial process, means being features which in the finished article appeal to and are judged solely by the eye, and essentially the same definition as in 1919. I should say that I don't think we've got it with us, but the replacement 1949 Act, which was scheduled as Schedule 4 to the 1988 Act, amplified that still further, because Section 1.3 was added to the section. I'll read it out and get your lordships a copy of it. Section 1.3, added to the 1949 Act in 1988, says this: a design shall not be registered in respect of an article if the appearance of the article is not material, that is, if aesthetic considerations are not normally taken into account to a material extent by persons acquiring or using articles of that description, and would not be taken into account if the design were to be applied to the article. That provision essentially echoes jurisprudence, the Amp and Utilux case in Bundle 2 at tab 16. I don't want to take much time on this, but just to show your lordships what the case was about. Sorry. Tab 6, I'm so sorry. This went to the House of Lords. It was a case about electric terminals buried deep inside washing machines. And what was said was that they met the definition contained in the 1949 Act because, it was said, if you look at the terminal, you can see its shape, you can appreciate its shape and function, and differentiate it from other terminals by looking at it. It would appeal to the eye. That notion was roundly rejected by the House of Lords, who said that the design was not within the scope of registrable designs. Lord Reid, at page 5, said at the bottom, his last two large paragraphs, I do not think we should either unreality to continue. There must be a blend of industrial efficiency with visual appeal. If the shape is not there to appeal to the eye but solely to make the article work, then this provision excludes it from the statutory protection. To avoid misunderstanding, no doubt in the great majority of cases with the Act will protect, the designer had visual appeal in mind when composing his design, but it could well be that a designer who only thought of practical efficiency in fact has produced a design which does appeal to the eye. He wouldn't be denied protection because that wasn't his object when he composed the design. And then turning to page 7, Lord Morris, the last complete paragraph on the page, the question is raised as to the sense in which the features in the finished article are to appeal to and to be judged solely by the eye. I think it's clear that the particular feature which is in question is under consideration must be seen when the finished article is seen. But the words of the definition point, in my view, to considerations other than of merely being visible. The phrase appeal to and judged solely by the eye denote features which will or may influence choice or selection. The eye concerned or with the eye not of the court, but of the person who may be deciding whether or not to acquire the finished article possessing the feature in question. This doesn't mean that the appeal or the attraction must be to an aesthetic or artistic sense, though in some cases it may be. The features must be such that they gain the favour of or appeal to some while meeting with the disfavour of others. And your lordships will see how that would potentially cover the bronze suite in the Hencher case. Which did not, however, qualify as a work of artistic craftsmanship because it was not, it had no artistic intent. We'll be looking at that in a moment. Beyond being merely visible, the feature must have some individual characteristic. It must be calculated to attract the attention of the beholder, and so on. And then he didn't think that the feature at the bottom of the page didn't think the features possess features of shape which can be said to have an eye appeal. And then Viscount Dillon dissented because he thought it might appeal to the eye of the electrician. And passing over that, well, you can see it at page 12. The question whether the shape or figuration of the terminal has features which appeal to and judged solely by the eye I find more difficult. I agree that the eye in question is the eye of a consumer in a visual test, customer in a visual test. The customers for terminals are electricians and those concerned with wiring. I don't think it impossible that an electrician looking at the respondent's terminal would say that it appealed to his eye. But anyway, moving on to Lord Pearson at page 14. From this point onwards, the phrase which in the finished article appealed to and are judged solely by the eye has been a statutory phrase to be interpreted. Just pausing there. Above that, he refers to some of the jurisprudence which led to the section 19 of the Patents and Designs Act. But passing on down to the next paragraph, not all such features constitute a design. It's not reasonable to suppose that the only limitations of the features are visible in the finished article. If that had been the intention, it could have been expressed much more simply. The emphasis is on external appearance, but not every external appearance of any article constitutes a design. There must be in some way a special, peculiar, distinctive, significant or striking appearance, something which catches the eye and in this sense appeals to the eye. And then going on to the end of the next page, dealing with the particular product, halfway down the last incomplete paragraph, it has no feature of shape or configuration which is special, peculiar, distinctive, significant or striking. There's nothing in its appearance which catches the eye. And going over the page, the very last paragraph, thus all the features of the terminal's shape are dictated by, in the sense of being attributable to or caused or prompted by the terminal's function of forming an electric connection between the two electrical conductors, the tab and the wire. Therefore, the respondent's design fails to comply with the negative statutory requirement mentioned above. For this reason, also, I hold the design is invalid. So, Lords, what we get from that is that the registered design scheme is indeed very much concerned with eye appeal, though it does not have to be artistic eye appeal. It was in the Hensher case, on the other hand, where the court was concerned with works of artistic craftsmanship, and I would say equally in the case of sculpture, which is a work of art, you are concerned to find aesthetic appeal to the eye, not merely the sort of appeal to the eye that justifies a registered design. And Mr. Justice Mann conveniently sets out the relevant quotations from the Hensher case. If your lordships would go to the core bundle at page 278. And perhaps I would invite your lordships just to read page 278 from the top right through to the end of paragraph 129.
What about paragraph 130?
The Merlin Mothercare case.
No, it says not easy to obtain much general guidance from this case, and he's talking about Hensher.
I think with respect, what he's saying is that you can't get a clear definition of what is meant by the word artistic. What is clear is that the word artistic is not something with no content. Because if it was something with no content, the product in Hensher and Restawhile would have qualified for protection, craftsmanship having been conceded. They don't give you a clear, bright line test, as the Americans call it, for what constitutes artistic, which is why I referred your lordships yesterday to what Lord Kilbrandon said at the end. Probably the best test in the end is to look at the thing and say, that is not a work of art. And the difficulty created by cases like that, and perhaps by this one, is the efforts to force something into a box it's not intended to fit, forces one to try to define the indefinable.
But if the test is whether a substantial section of the public genuinely admires and values the thing for its appearance and gets pleasure or satisfaction from its appearance, it's going to be a pretty difficult one to apply in practice.
Well, yes, indeed, without evidence, perhaps. Yeah. I think perhaps that puts the test a little bit too low in the context of that case, because I dare say one could have said that about the Bronx suite itself, bearing in mind its considerable success. People presumably bought it because it did give them satisfaction and pleasure to look at, apart from such comfort as it provided. I would rely on the other judgments more, the speeches rather, as indicating that something significantly more is needed of a work of artistic craftsmanship than is needed to satisfy the test for registration of a design. There wouldn't be much point in works of artistic craftsmanship otherwise. And certainly it wouldn't be necessary to call it a work of artistic craftsmanship. So, given those somewhat higher tests of the necessary artistry in Hensher, I would submit that the question of visual appeal in the context of sculpture must be a visual appeal which is at least as great as that needed for something to qualify as a work of artistic craftsmanship. It is not enough that it should be that minimum which would qualify something as a registrable design. Which prompts me to look at paragraph 15 of the appellant's case. If your lordships would go back to that. It is submitted. Sorry. It is. Case. Sorry, appellant's case, paragraph 15. If your lordship, in fact, perhaps it would be convenient to look at the previous page 8, where the quotation of Mr. Justice Laddie from the Metics case appears. Mr. Justice Laddie said that he thought Mr. Mead was close to the heart of the issue when he suggested that a sculpture is a three-dimensional work made by an artist's hand. Now that, I would say, bearing in mind the words made by an artist's hand, does indeed approach closely the test for sculpture. It imports some sort of intention of producing a work of art, of just the same kind of artistry that qualifies a work of artistic craftsmanship as a work of artistic craftsmanship. But my learned friend says you can't consider artistic merit, or artistic quality, I think is the word in the Act. You can't consider, if we turn to paragraph 15, you'll see what he says. It's submitted that of all the judicial pronouncements on the subject, the one which comes closest to stating the test is the statement of Mr. Justice Laddie in Metics. Don't quarrel with that. Provided it's read with the final words of section 4.1a of the 1988 Act, irrespective of artistic quality. Then he deduces from that, if a three-dimensional work is made for the purpose of achieving a visual impact, it is a sculpture. And that definition is a definition which is apt to cover that which is the minimum registrable under the Registered Designs Act, as we saw from AMP and Utilise, and what is needed to constitute a registrable design. Finally, before I leave copyright, there's one point to come back on. If your lordships would turn to bundle 6, I hope tab 20 has been inserted in it. Sorry, there is one thing I should have taken lordships to. Back in Mr. Justice Mann's decision at paragraphs 134 to 135, he arrives at his conclusions on the question of artistry in the work of artistic craftsmanship. And as I've already said, that was, well, we see from 133. With those authorities in mind, I turn to the question of whether the stormtrooper helmets and armour are works of artistic craftsmanship. I'm prepared to assume that the ultimate production of these articles was an act of craftsmanship. So, in that respect, the case was on all fours with Hencher, where the point was conceded, and perhaps reasonably conceded for all we know. Mr. Ainsworth can fairly be called a craftsman. He produces high-quality products and has a justifiable pride in his work, not a slavish copier or a jobbing tradesman. Production of the helmets and armour required the activities of craftsmen to realise the vision of the creators of the film in this respect. However, I do not consider their works of artistic craftsmanship. So far as their conception is concerned, they plainly were not. Their purpose was not to appeal to the aesthetic at all. It was to give a particular impression in a film. That was what Mr. Lucas and Mr. Quarry set out to do. It was no part of their purpose that it should in any way appeal as a piece of art, or that it should be admired for any aspect of its appearance as such, or that it should do anything more than was necessary to give the correct impression of the character inside and perhaps an environment when used in the film, with all the assistance that the techniques of filming can do to enhance an impression. If one takes the product of the arts and crafts movements as an exemplar, the helmet and armour share nothing of the conceptual purpose of such products. A work of artistic craftsmanship does not have to be something which William Morris would have been proud, but it's not wholly irrelevant in a case like the present to consider whether he would recognise it as having anything to do with what his movement is seeking to do. I do not think he would. I stress I don't propose that as a general test. It's I who have to decide this case, not the ghost of William Morris. It was merely a way of making a point in a case as striking as the present. That was not changed when the conception was put into operation. The purpose remained the same. Unlike a work of artistic craftsmanship, they were not intended to sustain close scrutiny. They carried their own acts of deception. What looked like corrugations of a gas tube are in fact painted on, as are some apparent vents. That deals with the stormtrooper helmets. The same applies to the armour. Its origins and purpose and conception were in substance the same as the helmet, and its ultimate purpose was the same. It fails to be a work of artistic craftsmanship for the same reason. And he determines the same in relation to all the other helmets and associated items, again for the same reason.
So you say if the craftsmanship is not artistic, the object that's produced can't possibly be a sculpture?
Yes. Yes, I do.
I mean, that's the point you're making.
It is.
Yes.
And there's no appeal against those findings. Indeed, there wasn't even an appeal to the Court of Appeal. And then, Lords, very briefly, the Northrop case at tab 20, just to pick up a point my learned friend made about originality and the requirement of originality making some sense of the notion that props will in general be works of sculpture if they appear in a film. Just to explain or to show your lordships what has been said about the requirement of originality in copyright cases, Mr. Justice McGarry, if your lordships can turn straight to page 68.
Which volume are we in?
Oh, sorry, so sorry.
One of the more irritating things about the bundles in this case is that they start their tab numbering afresh each time.
Yes.
So unless we hear very clearly
I'm so sorry,
which bundle we're in, we don't know where to go.
It's not my fault. Tab 6. It's the,
Bundle 6.
Bundle 6, I'm sorry.
Yes, tab.
Yeah.
Which is equally irritating because it's too big to get into our bookcases.
I'm
I think the list of complaints about the authorities in this case is growing.
Sorry, my lady.
What's your fault? Sorry?
There may be a design failure on our part.
There's a further one, which is the manner in which it's put on the memory stick, so far as I'm concerned, makes it absolutely impossible to
Get to it.
actually access it. But
I've given up using mine, I have to admit. But at least you can mark it in ink on the copy. I only want a short passage from this, page 68. The important point is that originality in the law of copyright is not the same as novelty. The context of this case was a spare parts case. Somebody was selling, I think to Egypt, spare parts for old-fashioned British looms. There was a demand for these replaceable bits, and they were pretty simple, some of them, just washers, for example. Washers which have essentially got three dimensions: an internal hole, an external circumference, and a thickness. And there were drawings of such things. And then, if your lordships would turn to page 68, the 868 having been cut from the top of the page for convenience, and go down to line 23, I turn to the second main ground of defence on copyright in the drawings, namely that some of them are too simple to be capable of being original artistic works within Section 3. According to a very helpful tabular statement which the defendants prepared in the course of the hearing, there were rather over a dozen of the plaintiff's drawings which the defendants said lacked originality solely on the grounds of simplicity. There doesn't seem to be much direct assistance to be found in the authorities on the score of simplicity, but indirectly and on principle the matter doesn't appear to me to be particularly opaque. Copyright is concerned not with any originality of ideas, but with their form of expression, and it is in that expression that originality is requisite. That expression need not be original or novel in form, but it must originate with the author and not be copied from another work. And then cases cited. A drawing which is simply traced from another drawing, as your Lordship saw referred to in the Interlego case, is not an original artistic work. A drawing which is made without any copying from anything originates with the artist. The Act merely provides by Section 48(1) that a drawing includes any diagram, map, chart or plan, so prima facie, if there is anything which can fairly be called a diagram, it is a drawing, and that may be the subject of copyright. It may indeed be that something may be drawn which cannot fairly be called a diagram of a drawing of any kind. A single straight line drawn with the aid of a ruler would not seem to me a very promising subject for copyright. But apart from cases of such barren and naked simplicity as that, I should be slow to exclude drawings from copyright on the mere score of simplicity. I don't think that the mere fact that a drawing is of an elementary and commonplace article makes it too simple to be the subject of copyright, and the same must clearly apply to objects which are alleged to be sculptures. In this case, I've been taken through the drawings in question seriatim, been able to consider them again after the conclusions of the evidence, of the argument. I accept that some of them are indeed simple. They include a rivet, a screw, a stud, a bolt, a metal bar, a length of wire with a thread cut at one end, a length of cable with nipples at each end, a block of leather, a washer, and a collar. They're all carefully drawn to scale with precise dimensions and so on. And he says that they all qualified for copyright. Leonard's originality exception would not cut much from the ambit of the principle he tries to persuade your lordships to adopt. Can I then turn to the question of justiciability and start, if I may, by looking at substantive US copyright law, which my learned friend said was, I haven't got the exact quote, but essentially similar to UK law. We say that it is in fact very different indeed from UK law, though it did no doubt start with the same sort of concepts. It has diverged wildly. We have in this case at least the advantage that they speak the same language. One wonders how things would be if one were considering similarly divergent concepts in Japanese copyright cases or Thai copyright cases or Mexican copyright cases, as will have to be done if the courts accept wide jurisdiction to hear foreign copyright cases, and will have to be done not merely once, but possibly 50 or 100 times if somebody brings a worldwide copyright action which raises an interesting defence centring around an issue like functionality, which is evidently a controversial issue in the law of copyright, to which different nations have come to different conclusions, as we will see in the American context. And although my learned friend seeks to reassure your lordships that the principle of forum conveniens will deal with such difficulties, I'm afraid it doesn't. Owusu has sorted that out. If an English company is exporting throughout the world, to Thailand, to Mexico, to America, to Taiwan, to Japan, if my learned friend is right, he can be sued in this country under the copyright laws of all those nations, and Owusu says that you cannot exclude that case from consideration in England on the basis of forum conveniens. You will have to hear evidence from expert witnesses in all those territories to explain what their cases or what their jurisprudence means. You will have to have expert evidence there will have to be translations in many cases of the authorities referred to. At least in this case, we did have the advantage of being able to look at the American authorities with our own eyes and try to understand them. But in the ordinary case, one will be relying on somebody's translation of them, and probably an expert's somewhat unclear to us explanation of concepts which seem clear to him. That, I say, by way of in terrorem. Let me look in more detail at some of the details of American law. The first point I'd like to look at is the fundamental question of what copyright subsists in America. And take your lordships first to the US Copyright Code, section 101, which I think we'll find in bundle 1.
You're not dealing here with the point of principle. You're just showing us how terribly difficult US law is to apply.
Well, I'm doing it for two reasons, actually. There is a point of principle, yes, and it's this, that although my case is that there is no difference of principle between copyrights and patents, or rights which are registrable, depositable, or arise automatically, it happens to be the case that in America, my learned friend is not right that registration is not a requirement for copyright to arise in America. It is still a requirement, except in the case of Berne Convention copyrights. I'll be coming to that. So that's one aspect of what I wanted to show your lordships in the nature of American copyright law. But yes, in a sense, what I'm doing is in part showing your lordships how complicated US copyright law is, partly to justify my proposition that it would be wrong in principle for this court to say that the British courts, English courts, should now start looking at foreign copyright actions. When we look at the jurisprudence, I shall say that there is a clear principle on which your lordships can decide that foreign copyright actions should not be looked at here. And that's the local transitory action divide, which is a real principle in English law. And at least, if I'm right, it's a real principle. That is the principle your lordships can adopt.
It's got nothing to do necessarily with registration.
It's got nothing necessarily to do with registration, no. But as it just so happens, American copyright law does still have a requirement of registration, which I'll be showing you, lordships. Yes, but these are American works. And they were, in fact, registered. We see the registration certificates in the core bundle. If your lordships would... perhaps I'll just show you lordships those straight away. Core bundle, pages 57 and 61. Yes, these certificates at 57 relate to the relevant Macquarie drawings which appear beneath them in the bundle. Rather badly photocopied, but they're also reproduced at the back of the bundle as well in colour for convenience. But Lord, I don't want to spend too much time on what American copyright law consists of. Though, of course, in due course, I do want to look at the American cases on the local transitory principle in a little more detail. but at the moment I'm just looking at substantive US copyright law, and dealing, I hope, with the learned friend's submission that American law is so similar to English law that there's really no problem seeking to consider American infringement actions in the English courts. Section 101 of the American Copyright Code appears at tab 28 of Bundle 1, and the only relevant point is the definition on page 6 of the tab. Pictorial, graphic and sculptural works include two-dimensional and three-dimensional works of fine graphic and applied art, and so on. Such works shall include works of artistic craftsmanship insofar as their form but not their mechanical or utilitarian aspects are concerned. The design of a useful article as defined in this section should be considered a pictorial, graphic or sculptural work only if and only to the extent that such design incorporates pictorial, graphic or sculptural features that can be identified separately from and are capable of existing independently of the utilitarian aspects of the article. Now, that looks a bit like the definition of registrability of a design from AMP and Utilux. It appears to be no higher than that. But as we shall see, as applied, the Americans have got very confused. But before we look at that in more detail, if your Lordships would now turn to section 102, which your Lordships will find in Bundle 5 at tab 2. Just by way of explanation, something I hadn't previously understood was that these large section numbers come about because section 101 is the first section of chapter 1. And we're now looking at section 102, which is the second section of chapter 1.
Sorry, I've lost you. Where is it?
Oh, sorry, tab 2 of Bundle 5. We were just looking at the first section in chapter 1. We're now looking at the second section in chapter 1. Subject matter of copyright in general. Copyright protection subsists in accordance with this title in original works of authorship fixed in any tangible medium of expression, now known or later developed, from which they can be perceived, reproduced, or otherwise communicated. And then it sets out the various possible categories, including 5 pictorial, graphic, and sculptural works. And then it has an important exception at the end. It'll be, in no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it's described, explained, illustrated, or embodied in such work. Now that looks superficially like the familiar English principle that there's no copyright in ideas. But it hasn't quite worked out that way. If your Lordships would turn to page 9 of that tab. The explanatory notes that went with that section rather optimistically say, in adopting this amendatory language, the committee is seeking to draw as clear a line as possible between copyrightable works of applied art and uncopyrighted works of industrial design. A two-dimensional painting, drawing or graphic work is still capable of being identified as such when it's printed on or applied to utilitarian articles such as textile fabrics, wallpapers, containers and the like. The same is true when a statue or carving is used to embellish an industrial article, or, as in the Mazer case, is incorporated into a product without losing its ability to exist independently as a work of art. That's where a statue was used as a lampstand. On the other hand, although the shape of an industrial product may be aesthetically satisfying and valuable, the committee's intention is not to offer it copyright protection under the bill. Unless the shape of an automobile, aeroplane, lady's dress, food presser, dare I say sandwich maker, television set or other industrial product contains some element that physically or conceptually can be identified as separable from the utilitarian aspects of that article, the design would not be copyrighted under the bill. Again, perhaps one might think that going to the example of the cow-shaped sandwich maker, maybe one can see how that would apply to it. The cow shape might be separable conceptually from the function of making the sandwich. But suppose it was making a cow-shaped sandwich by means of a slightly differently sculpted punch inside it. And one shouldn't perhaps ignore the fact that the sandwich maker is setting out to make an attractive sandwich. It's putting a pattern of lines on the sandwich that look nice on it.
Breville's is scallop-shaped.
The Breville's is scallop-shaped. Anyway, that's how the principle is defined. Then we'll look at some cases in a moment, which I'll get to on that. But while we're looking at the sections, the requirement for registration of copyright in the US, the US has always had and still has a copyright office at which copyright works need to be registered before they can be sued on. And we've seen the certificates in the papers. Oh yes, sorry, if you look at tab 3 in bundle 5, that point is made. Section 411, except for an action brought for violation of the rights of the author under section 106A, and subject to various exceptions, no civil action for infringement of the copyright in any United States work should be instituted until pre-registration or registration of the copyright claim has been made in accordance with this title. In any case, however, where the deposit, application and fee required for registration have been delivered to the Copyright Office in proper form and registration has been refused, the applicant is entitled to institute a civil action for infringement if notice thereof, together with a copy of the complaint, is served on the Registrar of Copyrights. The Register may, at his or her option, become a party to the action with respect to the issue of registrability of the copyright claim by entering an appearance within 60 days after service, but the Register's failure to become a party shall not deprive the court of jurisdiction to determine that issue. And then, in the light of certain jurisprudence, one case of which I'll show you, about fraud on the register, there's a provision about what constitutes or what's the effect of inaccurate information on an application of registration. If your lordships would turn to page 5 of the tab, halfway down there's an exception, and I should have done but I haven't found out just exactly how this exception is incorporated in the provision, but you'll see there subsection A substituted except for actions for infringement of copyright in Berne Convention works whose country of origin is not the United States and subject. So it seems that that particular requirement doesn't apply to foreign works, but it does still apply to US origin works like the Macquarie paintings in this case. The reason for that reference to the Berne Convention is this. If your lordships would look in bundle 1 at tab 27, the Berne, or the relevant provision of the Berne Convention set out, Article 5, it says this: the enjoyment and the exercise, tab 27, subparagraph 2 of Article 5. Subparagraph 1 provides for authors to enjoy in respect of works which they are protected under this convention in countries of the Union other than the country of origin, the rights which their respective laws now or may hereafter grant to their nationals, as well as the rights specially granted by this convention. In other words, leaving aside such rights as are specially granted by the convention, in any copyright country, in any member of the Berne Convention, you get in a foreign state the same rights as are given to the nationals of that foreign state, or at least as good as that. Paragraph 2 gives you a bit more, or potentially gives you a bit more. The enjoyment and exercise of these rights shall not be subject to any formality. And that's the reason for that exception I showed you, Lordships, to the registration requirement in the States. Foreigners are entitled to rely on the Berne Convention in the States to have their copyright arise without formality. And then it goes on to say, such enjoyment and such exercise should be independent of the exercise of the existence and protection in the country of origin of the work. Consequently, apart from the provisions of this convention, the extent of protection, as well as the means of redress afforded to the author to protect his rights, should be governed exclusively by the laws of the country where protection is claimed. In other words, if you're in the US, you get the protection which the US accords to copyright works in the US. What it doesn't do is to unify the law of copyright throughout the world. It's a pity it doesn't, because if it did, there might be some sense in a worldwide copyright action. But it gives everybody a bundle of worldwide rights, each one of which is defined by the local copyright statute. The significance of the US Copyright Office is not purely formal. It is not just a matter of depositing a work. The US Copyright Office scrutinises applications or deposits, and it sometimes rejects them, particularly in the area of clothing. Let me take your Lordships to tab 4, bundle 4, tab 4 for that point. Bundle 4, tab 4 is a publication, as I understand it, by the US Copyright Office, explaining its practices. At paragraph 1, it says works subject to copyright protection may secure copyright registration in the Copyright Office. Determining the registrability of masks and costumes requires the application of the definition of pictorial, graphic and sculptural works and useful articles I set out, and then it sets out the definitions, some of which we've already looked at. And then going down to the bottom of page 2, halfway down page 2, where it says emphasis added, the Copyright Office has generally refused to register claims to copyright in three-dimensional aspects of clothing or costume designs on the ground that articles of clothing and costumes are useful articles that ordinarily contain no artistic craftsmanship separable from their overall utilitarian shape. A two-dimensional design applied to the surface of clothing may be registered, but this claim to copyright is generally made by the fabric producer rather than the garment or costume designer. Moreover, this claim to copyright is ordinarily made when the two-dimensional design is applied to the textile fabric and before the garment is cut from the fabric. And then there's a reference to a House report. Over the past few years, next paragraph. Over the last few years, however, the Office registered a few narrowly drawn claims in certain three-dimensional, fanciful or animal-shaped items that can be worn. Some of these claims have been the subject of litigation. And then, if your Lordships would go to the top of page 3, in one of the leading cases on masks, masquerade, novelty and unique industries, the court held animal masks were not useful articles because nose masks have no utility that does not derive from their appearance. The masks were configured to resemble the nose of a pig, elephant and parrot and were found to be copyrightable. In Facilis and McDonald's Corporation, copyrighting a Halloween mask depicting a man in the moon was considered to be valid, but summary judgment was granted in favour of the defendant due to lack of substantial similarity. While the cases consistently treat costumes as useful articles, the applicable standards for determining separability are unclear. In Animal Fair against Amfesco, the District Court upheld copyrighting a slipper depicting a bear's foot. While treating the slipper as a useful article, the court concluded that the whole shape and design were recognisable as a fanciful article rendition of a bear's paw. The Eighth Circuit affirmed without written opinion. The test of conceptual similarity was raised again in a case involving children's backpacks. But I want now, if I may, to move on to a case, a whimsicality in tab 3, bundle 3 at tab 37. I'm sorry, I should have written I should have taken it. It's on page 4 of the document we've just been looking at, tab 4 of bundle 4. Under paragraph 6, examining practices with respect to garment designs, the second paragraph there, the general policy of non-registrability of garment designs will be applied not only to ordinary wearing apparel, but also to period and historical dress and uniforms. Wearing apparel incorporated into theatrical productions will likewise be treated under the standards applying to garment designs in general. Thanks.
I haven't quite understood what the effect of registration is under the section which you referred us to in Bundle 5, Tab 3. It says no civil action should be instituted until pre-registration or registration has been made. I mean, if you fail to register, can you claim infringement and then claim to register at that time, or have you got to register before the infringement, or what?
It seems that you can start the proceedings, make the registrar a party to the proceedings, and the registrar may or may not turn up, and the court can then continue to hear the case. But there's a further provision that the court has to notify the register.
Yes.
I didn't take your lordship to that, but it has to notify the register of the outcome of any copyright proceedings, any copyright proceedings.
Yes, and if there's an allegation that inaccurate information has been included on application, the registrar also has to be notified. But the effect of that is that works fine in the United States, but yes. It would be what would be the effect if foreign proceedings could be begun in respect to the unregistered United States copyright?
Foreign copyright work would presumably be exempt from that requirement because that would be seen as a formality, and we've seen that there is an exception for foreign works in relation to that requirement.
What about the other way around? What would be the position if you could sue in the United Kingdom on an unregistered United States copyright? Your argument would be that these proceedings, these provisions don't work very well.
Well, no, they don't, because what's the English court supposed to do? Is it if one had, for example, an English company owning some American copyrights, which is not impossible. I mean, one thinks of English companies making its works here, but it wouldn't necessarily be so. An English company may have a subsidiary in America that has drawn the relevant works and would therefore have American copyrights subject to registrability, which it wants to sue on when somebody infringes them in the States. But it wants to sue on them in England because the defendant is in England. The defendant does not believe the design would have been registered, or should have been registered. He thinks it should have been registered and hasn't been registered. What's the English court supposed to do about that? Suppose the American Copyright Office has in fact refused registration of that particular design on the basis that it's a functional garment. What's the English court supposed to do about that? And in deciding the issue of whether the registry got it wrong, which standards is it supposed to apply? Well, we'll look at some cases in a moment to make the point about the difficulty. Can take your lordships to a couple of cases which illustrate the kind of difficulties that can arise. Bundle 3, tab 37, for a whimsicality case. Appellant Whimsicality and Appellee Ruby's Costume are competing costume designers and manufacturers. Believing that Ruby's was selling knockoffs of its costumes, Whimsicality commenced the instant action and sought initially a preliminary injunction, and so on. Going down to the next paragraph, the district court held that Whimsicality had registered a copyright on its costumes, but that the costumes were not copyrightable. The parties therefore devoted most of their arguments on appeal to the latter issue. We agree with the result reached by the District Court, and we affirm the dismissal of the copyright claim and the denial of injunctive relief, but we do so on grounds other than those relied on by the District Court. We hold that Whimsicality obtained its copyright registration by misrepresentation of its costumes to the United States Copyright Office. We therefore decline to reach the issue of copyrightability, since proper registration is a prerequisite to an action for infringement. Since we find bad faith on the part of Whimsicality, we vacate that part of the order which declined to award attorneys' fees to Ruby's pursuant to Section 505, and we remand the case to the District Court for determination of that issue in light of its opinion. And going down to paragraph 8, Whimsicality's demand was based largely on the fact that in 1988 and 1989 it sought and received copyright registrations for 6 of its creations: the pumpkin, the bee, the penguin, and so on. Nowhere in the copyright applications, however, is the word costume used. Instead, Whimsicality called its creations soft sculptures. The costumes were displayed during the oral argument, and our visual examination disclosed that the costumes lack any firm form unless worn by a person or carefully laid out on a flat surface. And then, next paragraph, the explanation for this doctor's deception is not a mystery. The Copyright Office considers costumes to be wearing apparel and consistently rejects applications to register them. Whimsicality was aware of this at the time it sought to register its costumes. The District Court asked Whimsicality's attorney if you took this photograph of a child wearing the costume and sent it to the Copyright Office and said we're filing an application for a children's pumpkin costume, what would happen? The attorney replied it would probably be rejected. And then going down to paragraph 13, the District Court didn't regard that as sufficient grounds to constitute a defence. Going down to paragraph 13 of the Court of Appeal's judgment, we've long held that clothes as useful articles are not copyrightable. While the pictorial, graphic and sculptural aspects of useful articles may be copyrightable if they're separable from the article physically and conceptually, clothes are particularly unlikely to meet that test, the very decorative elements that stand out being intrinsic to the decorative function of the clothing. In any event, the useful articles standing alone may never be registered. The registration must describe the separable elements, see, and so on. Pelly argues that although clothing may not be copyrightable, masquerade costumes are an exception to that general rule. In view of our disposition of this matter, we need not address that contention. Whimsicality doesn't assert that it's ignorant of the case law as to the copyrightability of garments. And then, in the middle of the paragraph, Whimsicality had several options. It could have commenced an action for a declaratory judgment to compel the Copyright Office to change its classification of costumes as per se uncopyrightable. More practically, it could have acknowledged in its application that the articles in question were costumes and have requested registration for only the features it claimed were separable. That was the approach taken by the amicus in the instant case. And then, top of page, paragraphs, next page. Instead, Whimsicality chose to classify its creatures as soft sculptures with no useful functions as wearable objects. Unlike a useful article, a sculpture, soft or hard, is inherently copyrightable, assuming it's an original work. Maser and Stein. Unfortunately for Whimsicality here, the evidence demonstrates not only that the costumes were not soft sculpture, but that Whimsicality knew full well that no reasonable observer could believe that the costumes were soft sculpture. And then paragraph 19, knowing failure to advise the Copyright Office and so on might bring an end to the action. So that was an action which failed for reasons connected very closely with the presence in the system of the United States Copyright Office. There's another interesting example of that going in a sense the other way at Bundle 3, tab 32.
Are you going to tell us what you get out of this after you've dealt with this other case or now?
Yes. I'll tell you, Lordship, now what I get from it is that American law is complicated, uncertain, and is closely tied in, particularly in cases involving costumes, with what seems to be an underlying and perhaps to us somewhat incomprehensible question of principle. Well, it's not entirely incomprehensible, that the principle of giving different consideration to functionality considerations is something which is built into our law. But it's built into our law in a very different way, by way of what I've described as a gradation of different kinds of protection from the, now, the unregistrable design, which even allows you to protect things with no visual significance, through the various things up to sculpture at the pinnacle. Our system is quite different from this. This system is a system which contains very difficult questions illustrated by that case about what is and what is not a copyrightable work. And in addition to that, there's the point about the importance in the American system of registrability. And the importance of that is not to my submissions, because in my submission registrability makes no difference. Copyrights, even if unregistrable, should be treated in the same way as patents. And I'll be taking your lordships to the English authorities, which I say establish that there's no difference of principle between copyright cases and patent cases. But my learned friend's submission is that there may be a difference between patents and copyrights, and I therefore rely on this American jurisprudence as an indication that actually American copyrights, perhaps uniquely in the world, are something which should be regarded in the same light as patents, because they have this curious registrability requirement built into them.
Am I right in thinking there hasn't been any reference in the cases to Article 8.1 of the Rome II regulation?
I don't think there has, Lord. What is Article 8.1 of Rome II?
Just on the question of application of the foreign law and difficulty, that provides that the law applicable to a non-contractual obligation arising from an infringement of an intellectual property right shall be the law of the country for which protection is claimed. So that is based on the assumption that intellectual property rights are justiciable outside the country of grant. And of course, the difficulty of application of the foreign law has never been a reason for having a different choice of law rule.
Except that it scares the family lawyers rigid.
And that's why in family law the lex fori is often the applicable law.
Well, that provision has not been referred to.
Both the judgments regulation and the Rome II regulation do proceed on the basis that some types of foreign intellectual property claims are justiciable.
Yes, well, that's undoubtedly the case within the community context.
Yes.
And insofar as one's looking at things in a community context, then it is only common sense.
Well, Rome II is universal.
Well, I'd better have a look at that, Lord, because I'm not ready to deal with that point. I'll park that, if I may, and come back to it. Perhaps I can pass over the case I was about to show your lordships. It's more another amusing example of the application and the difficulty of applying American law. But there is one final case on it, Bundle 5, tab 11, bringing the position somewhat up to date in a sense. Bundle 5, tab 11, a case from 2005 called Galliano and Harrar. Poe, just to tell your lordships what the facts were, without taking your lordships to the case I was going to take you, but I'll pass over it, was perhaps more amusing than anything else, but it was a case about a transparent bikini made of transparent plastic. The defendants contended it was an article of clothing and had been wrongly registered. The claimant said, I'm a sculptor, and this was an amusing parody of a bikini and was never intended to be worn. And the court sent it back for more evidence. But more significantly for present purposes, Galliano and Hurrah.
Just going back to the previous case, the Copyright Office didn't have to be a party to that case, even though it was the basis of the objection was that there had been misrepresentation.
No, it didn't, but as you've also seen from the rules, it had to be notified of the proceedings, and it would in due course have been served with the result of the proceedings. And in fact, of course, well, it was in fact registered there, but it still well, at least it needed to be told of the result of the proceedings.
I mean, there would be a serious issue if the Foreign Patent Office and the Copyright Office had to be a party to proceedings.
Well, I would say that, yes, that would be an even more serious issue, certainly. The rule provides that the Copyright Office may be a party to the proceedings if it chooses to come along. And there's no real possibility of them doing that in England.
Well, there would be a possibility, but it would be extraordinary if they did.
Yeah, it would be extraordinary, yes. Yeah. If it refuses to register, it was served with it has to be served with the proceedings and can appear if it wants to. So I suppose in a sense it's made a party by being served with the proceedings, in that sense at least. And as we saw from the case we just looked at, one possibility is to certiorari them, or mandamus rather. Lords, this case I only want for its indication of the difficulty of applying the garment functionality test. It's at tab 11. If I can take it up straight away at paragraph 22. It was a case about uniforms which Galliano had designed for somebody, which the somebody then started having copied by somebody else. Paragraph 22, there's little doubt that clothing possesses utilitarian aesthetic value, it's common ground. But then, at paragraph 23, although the statutory language ostensibly requires that two conditions be satisfied, the consensus among courts and academics is that because the statutory language was essentially listed from a case predating the legislation, Section 101's separateness requirements implement what is called the conceptual similarity test. There are at least 6 distinct variations of this test, and courts have twisted themselves into knots, trying to create a test to effectively ascertain whether the artistic aspects of a useful article can be identified separately from and exist independently of the article's utilitarian function. And then it refers to the pivot point case, which is a sprawling, comprehensive exegesis of conceptual similarity jurisprudence. Although it is not binding on this court, pivot point represents, by orders of magnitude, the most thorough and persuasive analysis of this question in any circuit. And then going to paragraph 28, acknowledging the comprehensiveness of that opinion, however, is not tantamount to applying it here. We do not reject the pivot point test in this circuit, but we decline to apply it to the instant facts for several reasons. And then at paragraph 35, thus, a clothing design that is intended to be used on clothing is copyrightable only to the extent that its artistic qualities can be separated from the utilitarian nature of the garments. How to conduct the conceptual separation is in turn what continues to flummox federal courts. Now, Lords, I ask rhetorically, if a foreign copyright law contains a principle that continues to flummox federal courts, how is an English court supposed to handle such a question? Is it supposed to pick the principle it likes best from the circuit which seems to make most sense? Should it perhaps put itself in the position of the Supreme Court trying to reconcile these principles? Should it perhaps devise its own test and see if it can't do a bit better than what's been done already on the other side of the Atlantic?
That's not really an argument of principle, because that problem can arise in any case where there's a foreign applicable law, where you have a difficult question under the foreign law. Yes,
it can. I accept that. But if it's right that your lordships have a choice between deciding whether, as a matter of principle, copyright actions and IP actions generally fall within the local action doctrine, then in deciding which way your lordships wish to jump on that issue, the fact that IP laws are so difficult and different in other jurisdictions is a reason of policy which your lordships might consider justified waiting to take this step before there has been some degree of international harmonisation of IP laws. And that, if I may say so, is one of the points Lord Justice Jacob was making, and it was a good one. It's too early to take this step. It's something which makes a great deal of sense in future. But at this stage, the courts should continue to apply the local doctrine, because at the moment, in the absence of proper harmonisation of IP laws, to take the step which a learned friend invites your lordships to take is to take a step which is likely to cause huge inconvenience, particularly when one adds the Owusu ingredient to what he's inviting your lordships to do.
It's not very representative, though. You've just picked the United States, which may be an important market, but there are a large number of other countries where there may be either no copyright law, as I understand is the position in some, or copyright law which is very easy to understand, or indeed is modelled on common law principles which we share.
That's true.
Yes, so why do we just say, throw up our hands or treat it as special just because one country? This one should do surely a world survey to evaluate the argument you're putting forward.
With respect, I would say the opposite. That's something which the legislature ought to do. If the legislature thinks that it's time the local action doctrine, and I'll be taking your lordships to the English jurisprudence, because in my submission that there is a lot more material in favour of my submission than your lordships might have imagined from the what you've heard so far about it. When you see the volume of intellectual property lawyers' views on the point, and I was showing your lordships also American cases on the point, which also say that the local action doctrine applies. I don't shrink from the fact that other people have said the opposite, because other people have.
But you do accept that within the EU, the principle has been substantially eroded, even though the EU has not yet got to a point of unification of
yes, I do.
laws.
I don't shrink from that. I'm afraid things have happened in the EU that make little sense to us, as the Owusu case serves to emphasise.
Well, no, because we've signed it. We signed up to the regulation.
We did.
And the convention.
Yes, and there are some that say that, it is apparent that the forum non-convenience doctrine was, it seems, knowingly signed away by us, because the point was discussed in the course of negotiating the convention, and we didn't insist on its inclusion. But that's, with respect to a different point, that's all intra-community. The special exceptions in in Article 22 are intra-community ones. What we're concerned with here is the position vis-à-vis the rest of the world. And although Lord Mance puts to me rightly that there are many Commonwealth jurisdictions which have similar laws, an answer to that point would be a Commonwealth convention to deal with the reciprocal enforcement of copyright around the Commonwealth, which could possibly be conveniently achieved in view of the degree of uniformity that exists within the Commonwealth. But that's the sort of thing which I would submit it's for the government or the legislature to consider. It would probably be a sensible thing to have within the Commonwealth, if assuming, again, that other Commonwealth countries want to join in. Why should we do it unilaterally? Lords, there's just one further point I wanted to show you from US law before I get on to something else, which is on a slightly happier note in a sense. Bundle 6. Tab 16. Tab 16. The definition of infringing act in America, which seems refreshingly clear. Section 2 of Chapter 6 sets out two categories of infringing importation or exportation, and then there's an exception, or a number of exceptions, in subsection 3. First is government purposes. Secondly is this: importation for the private use of the importer and not for distribution. And then I notionally insert the word A, by any person with respect to not more than one copy or phonorecord of any one work at any one time. Or B, by any person arriving from outside the United States or departing from the United States with respect to copies in the plural, or phonorecords in plural forming part of such person's personal baggage. So we see here two exceptions built into one. Private importation of one copy, ordered, if you like, on the internet, put into the hands of the purchaser's carrier in the UK, not an infringement. And of course, many of Mr. Ainsworth's sales are of just that kind. What Mr. Ainsworth has been doing is selling these outfits to people who like to dress up as stormtroopers. There's something called the 501st Legion, which has chapters all over the world, and people either make their own or buy stormtrooper outfits and turn up at functions. We were half expecting to see a few outside your lordship's court, but they weren't here. But they could have been. They turn up to weddings, they turn up to the openings of films, and they're all dressed up in these outfits. And what Mr. Ainsworth is primarily doing is selling these outfits to people who want to dress up like that. He has the advantage of having the original moulds, and he can sell more authentic ones than people who make their own. Though the evidence showed in the case there are very strict standards which people need to comply with if they want to belong to the 501st Legion. I draw your lordship's attention to that provision to emphasise that, well, 2 points actually. One point I make is this, that one of the things which is sought by the process, by the means of allowing a foreign infringement action to take place in this country, is to stop somebody in this country from exporting goods to America. Now, that can, in most cases, be sorted out without the need for the kind of extension of jurisdiction that the learned friend is contending for. In the vast majority of cases, and what in fact happens nearly all the time, is that you simply use English law to get an injunction against an English defendant. You find out where somebody's operating from, and you sue him for copyright in that territory. You close him down. He stops exporting. There's no need, apart from the need for damages perhaps, but from the point of view of closing somebody down, you attack him where he operates using the local law, and you stop him. It's a curiosity of this case that in fact any injunction granted in this case, whether under English law, well, no injunction could be granted under English law if I'm right about sculpture, and what's more, under American law also. Mr. Ainsworth's primary activity appears not to constitute any infringement of American copyright.
Well, I venture to remind your lordships and my lady that my learned friend sought to reopen many of these aspects in his application for permission to appeal. He was not allowed to do so. We are concerned at the drift of an argument that appears to suggest to you that there was in fact no infringement of US copyright, contrary to the judge's findings.
I'm not suggesting any such thing, my lords. The learned judge never came to formulate a form of injunction in this case. There was infringement in the United States of quite another kind. Mr. Ainsworth advertised in a New York newspaper 3 times, I think. And as a result of that, no doubt some sales were made in the United States. So there was infringement within the definition of the American point. The reason I make this point is that in the end it's unlikely that an injunction of very great value will be granted to the claimants.
There was an injunction. There was an injunction granted. You agreed to it. Stopping him shipping the things to the United States.
Oh, Lords, I beg your Lordship's pardon. I've completely forgotten that we have, in fact, formulated a form of injunction, in which case I'm quite wrong about that. Right. Oh, right, okay. I forgot. I beg your Lordship's pardon. In any case, the other point, the more important point I'm coming on to, quite apart from the facts of this particular case, the really important point is this, that under Section 25 of the Civil Jurisdiction and Judgments Act, the court in this country has jurisdiction to make injunctions in support of foreign litigation. That is set out in, or that provision is in Bundle 5 at tab 1. Section 25 of the Civil Jurisdictions and Judgments Act 1982, interim relief in England in the absence of substantive proceedings. This was passed initially in order to comply with the Brussels Convention and provides in its initial terms for interim relief in aid of what one might call community proceedings. But there is a provision in subsection 3A that Her Majesty may by order and Council extend the power to grant interim relief, and that was in fact done in 1997, if your Lordships would turn the page, by order in Council, which extended it to all proceedings throughout the world. So that one possible and perhaps convenient way of handling the problem would be for the courts to start granting injunctions under Section 25. That would not involve directly enforcing foreign copyright laws. They would be interim injunctions, though of course the jurisprudence already shows that such relief can be granted in aid of final judgments granted abroad, Morava relief and so on.
Well, doesn't that depend on the scope of the principle for which you contend? If you say these are non-justiciable, then rather than no jurisdiction, then Section 25 might not apply at all.
My position is that there is no English jurisdiction to handle foreign copyright disputes because they are essentially local actions. Your Lordships have to consider whether the doctrine of local actions does apply to copyright disputes.
So you don't make use of the concept of justiciability?
My point is the concept of local and transitory actions. This is a local action over which the English court has no jurisdiction. Justiciability would be a different point and not so helpful to me.
And so you don't contend for non-justiciability?
No. It's possible that the whole point about the difficulty of dealing with such matters could raise that. But the point is simply a jurisdiction point. The English courts, as a result of the local action doctrine, simply has no jurisdiction over the subject matter of foreign copyright disputes. But Section 25 could provide a means of providing effective relief in appropriate cases in aid of a foreign copyright dispute, which would avoid the difficulty, the very great difficulties created by saying that the local action concept doesn't apply to foreign copyright actions or foreign IP actions generally. So, Lords, I now turn to the question of whether Mozambique rules, or the local action doctrine, does and should apply to IP cases. It is potentially a hugely important issue. It is perhaps surprising that it should come up for the first time in a case involving such trivial amounts of infringement. And that may be because in the vast majority of cases, matters are dealt with in other ways, by suing somebody for local infringements of the copyright in the area where he's actually making things. It's only because of the very peculiar circumstances of this case that English law can't be enforced against Mr. Ainsworth to close him down, because he's not infringing. The first question is, what is the local action doctrine? There's a nice definition of it in the leading United States case, strongly based on English principles. That's Livingston and Jefferson in Bundle 3 at tab 29. Livingston and Jefferson was a case in which, as we see from the headnote, a citizen of the state of New York brought against Thomas Jefferson, a citizen of the state of Virginia, an allegation of trespass, which was said to have occurred in the city of New Orleans.
Is this trespass to the person?
No, trespass to land. There were fairly elaborate trespasses which are described in the declaration. By force of arms, was a close and parcel of land, did break and enter, and a whole lot of spades and things were taken. Then did cut in pieces and utterly destroy cartloads of earth and so on. It looks as if some sort of military activity was going on. And the third count charged him with entering on the close called Livingston's Canal, driving off his workmen and servants, interrupting their work during the said period, whereby the work being unfinished, the river Mississippi rose, carried away the materials, destroyed and filled up the said canal, and so on. The fourth count charged him with entering on the northern part of the said bouture, driving off the plaintiff's workmen and servants, engaged in making a levee, embankment or dyke to restrain the annual indentation of the river Mississippi, interrupting their work, during which the river rose, destroyed the levee and inundated the close. So these were serious trespasses. And Circuit Justice Marshall, as he then was, dealt with the matter, and the relevant passage is on page 6 of the tab, in the second column. Perhaps the first column, down at the bottom of the first column. In the case at bar, it's traversed for that purpose, and the question is whether this be a case in which such traverse is sustainable, or in other words, where the courts have so far extended their fiction as by its aid to take cognizance of trespasses on lands not lying within those limits that bound their process. They have, without legislative aid, applied this fiction to all personal torts and to all contracts, wherever executed. To this general rule, contracts respecting lands form no exception. Penn and Baltimore. It's admitted that on a contract respecting lands, an action is sustainable wherever the defendant may be found. Yet in such a case, every difficulty may occur which presents itself in an action of trespass. An investigation of title may become necessary, and so on. But then, in the middle of the next column, the distinction taken is that actions are deemed transitory where transactions on which they're founded might have taken place anywhere, but are local where their cause is in its nature necessarily local. And that definition is stated without being specifically linked to land. It's a definition, I would submit, of general import.
But this is no longer good American law. If I read from the leading textbook on American conflicts of laws about this case. However, the weight of authority today is that the local action rule, if it exists at all, applies only to actions in which the title to land or an interest therein is in question, and then only in disputes that necessitate surveys, tract history investigations, and other miscellany peculiar to the locality, citing a 2003 case.
Look, whether that's right in relation to land is not the point I'm concerned about. As we know, in England also, the principle has been qualified by statute in relation to land. But the point I make is that that definition there is of broad impact, and as your lordships will be seeing from some American IP cases, that principle of the local action has been applied in IP cases to say that the American courts should not hear foreign IP actions in America. And I wanted it for the breadth of the definition, which is quite simple. The distinction between actions where transactions on which they're founded might have taken place anywhere, but they're local where their cause is in its nature necessarily local. And he quotes Blackstone as authority for that proposition. The distinction has been repeatedly taken in the books, recognised by the best elementary writers, especially Judge Blackstone, from whose authority no man will likely dissent. And then he goes on in the next column to refer to decisions of Lord Mansfield, which were then overruled in England by Dolson and Matthews after the American Revolution. And he points out the distinctions are expressly referred to and overruled, and the old distinction is affirmed. So this American jurisprudence, and it may be that the land aspect of it has been significantly qualified subsequently, is still based on a significant rule of English and American law differentiating between actions which could have taken place anywhere, or transactions on which actions are founded which could have taken place anywhere, and ones which are by their nature necessarily local. And I'll be looking at the cases in due course, which illustrate the application of that. But I want for a moment to look at the question of whether it's possible to draw a principled distinction between the issue of validity and infringement. And I want to approach that in two ways. By looking at the land law jurisprudence, and then by looking at the nature of IP actions. So far as the land law jurisprudence is concerned, it is clear that in both America and in England, the rule was not limited to actions about the title to land, but covered actions in which trespass was the only issue. In the States, that seems to have been settled, or at all events understood, slightly earlier than in England. If your lordships would turn back to tab 23, the case of Ellinwood and Marietta Chair. A very short quote up at the top of the last page. By the law of England and of those states of the Union whose jurisprudence is based upon the common law, an action for trespass upon land, like an action to recover the title or the possession of land itself, is a local action and can only be brought within the state in which the land lies. Once again, your lordships will note that it is not the local action, it is a particular species of local action. And it refers to the Mozambique case at the bottom of that page as further support for the proposition. And of course I'll be looking at the Mozambique case. So that case at least didn't draw any distinction between issues of title or questions of mere trespass. And as your lordships have already seen, in the Hesperides case, the House of Lords decided that even where there was no dispute at all about title, the local action principle made it impossible to bring a trespass action. And can I take your lordships to just one short quote from there? Lord Fraser, in Bundle 2, tab 20, last complete paragraph on page 29 of the printout. Talking about the Mozambique case, that decision, as interpreted in branch 2 of Rule 79 in Dicey, has been the subject of criticism from many sources. Mr. Kemp submitted that the criticisms were well-founded. The decision couldn't be distinguished in the instant case it should be appealed from. And then this is the important section, statement. The decision was based, as the speech of the Lord Chancellor clearly shows, on an historical distinction drawn in English law between local and transitory actions. Now, I emphasise that passage because when we come to look at the Court of Appeal in the Ovi Arab case, they seem to have thought that the Mozambique case was based entirely on the sovereign rights point, which is a different point, though it overlaps significantly with it. Here we see a clear recognition of the continuing validity of the distinction drawn between local and transitory actions, albeit, of course, in the context of land law cases, but saying that the distinction drawn in English law between local and transitory actions bars a trespass action, even though the title to the land is in no way in question. And I would say that's a very clear indication that the underlying principle is not based on the sovereign rights point, though that is sometimes perhaps an indicium which points in the direction of something being a local action. It is a different and overlapping, and in the present case, much more potent and important principle than the sovereign rights point. Turning then to the question of IP rights, And assuming, for present purposes, that the local action doctrine does apply to IP rights at all, and that, in my submission, is the main question, but if it does, then I would say there is an obvious analogy between the ownership trespass point in the land law cases in Mozambique and the validity infringement point in IP cases. Indeed, if anything, validity is, for several reasons, rather closer to infringement than trespass is to title to the land. Obviously, title to the land is a fundamental to trespass, but there may be no dispute about it. Similarly, there may be no dispute about validity. But validity, I would still say, is an issue which sits rather closer to infringement in most cases, in many IP cases. It's true that in some IP cases there are issues rather analogous to the issues that arise in commonly arise in trespass cases, such as, did the defendant do what is alleged at all? Was he there on that occasion? And then there are perhaps also analogous issues. Is this class of act capable of constituting an infringement of a copyright or a patent at all, such as importation for private purposes? Those are perhaps somewhat analogous to conventional trespass issues. But the usual infringement issue in an IP case is this. Has the relevant legislation resulted in the grant of a patent or a copyright which is broad enough to cover what the defendant is doing, which is almost, but not quite, as much of an inquiry into the doings of a foreign sovereign as the question of whether he got it right granting the monopoly in the first place. The test for infringement. And one might perhaps say that in the context of American copyright law, without wanting to go too deeply into American copyright law in particular, but the test of separability in American copyright law, in order to judge an issue of infringement, you ask, does the copyright cover those particular features? And you have to notionally separate out the non-copyright part from the copyright part, which establishes subsistence, which suggests that the infringement test is extremely close in America to the infringement test. I'll look at that a bit more in a moment. But even if you do regard infringement and validity as separate issues, there's still, in IP cases, very much two sides of the same coin. Sometimes a patentee has applied for a broad patent, and the issue is one of validity. Sometimes he's applied for a narrow patent, and the issue is whether it's been infringed. And sometimes the defendant is in a position where he can say, I don't care whether the patent is valid or infringed. What I'm doing is the same as somebody else's prior art, or not obviously different from it, and therefore the patent must either be invalid, or not infringed, but either way, what I'm doing is unexceptionable. So that rather emphasises the fact that the validity point and the infringement point are two sides of the same coin. It's what's called the Gillette defence, which, and the reference to that, I won't take lordship's to the case, Bundle 2, tab 18, page 480 at line 42. The notion that a defendant can say, and it's said in the case to be an important principle, that someone faced with a patent action should be able safely to copy prior art and not have to bother himself with the sometimes tricky question of whether the reason why he's safe to do it is because the patent's invalid or because it's not infringed. That's an obvious point. And that close analogy is vividly illustrated by the state of US copyright law applicable to the present case. We've heard a bit about the US functionality point, but it comes in two flavours. One flavour, as we've seen, is that the Patent Office refuses registration to garments. And if you call something a soft sculpture, you have deceived the Patent Office, and that doesn't work. That is a subsistence point. There's no copyright at all in the garment. On the other hand, if, as in the present case, the copyright owner has registered, so far as one can see perfectly legitimately, a picture of the relevant object, a painting by Ralph Macquarie of the sculpture, of the uniform. If he's registered a picture of it, then exactly the same principle of functionality, stemming from exactly the same qualification to the American Copyright Code, turns up not as a subsistence point, but as an infringement point. Because now what is said is that copyright painting is validly registered as a copyright painting, but the copyright does not cover the functional objects depicted in it. So there is, I would submit, no principled distinction which could justify, on the basis of the English local action rule, drawing any distinction between validity and infringement in the realm of copyright, and the same is true of patent law. And it was no doubt for reasons like that, which were argued before Mr. Justice Mann, that he too took the view that no principled distinction could be made between validity and infringement. But he then went, and that an action could be brought in this country for copyright infringement. But he went wrong in my submission by saying that the appropriate and modern way of handling such matters is to use the forum conveniens doctrine, so that only people in the position of Mr. Ainsworth, who does not submit to the jurisdiction of the American courts, will find himself on the end of an American action brought in England. In the ordinary way, if Mr. Ainsworth had a presence in the States, he would be sued there, and the forum conveniens rule would ensure that the proceedings took place in what is obviously the only sensible place for such proceedings to take place. Well, my lords, that's how things were at the trial, but now that a WUSU has been raised, it is apparent that Mr. Justice Mann's apparently sensible way of dealing with the obvious problems that would arise is no longer available. He was right when he said that no principled distinction can be made between copyright validity and infringement, but he was wrong to say that, therefore, the whole action is outside the local transitory of the local action doctrine. He should have said that because of the manifest inconvenience, the local action rule does apply. And on that note, can I take your lordships to some of the other things that have been said by IP lawyers in England on this topic, starting with Mr. Justice Aldous in the Castus Creative case at tab 2, bundle 20, tab 20, bundle 2, tab 27. What he said here was obiter, But the case had involved a threat. It was a threats case, and it was alleged by the claimant that the defendant had threatened the plaintiff then with infringement of UK, German and French patents. Threats to infringe, or an allegation of threats to infringe a British patent is actionable, but the claimants added into it the notion that there had been threats to infringe German and French patents. And it sought the plaintiff sought an acknowledgement that there was no infringement of the French and German patents. And as we see from the head note, the defendant, proceedings having been started for a declaration in those terms, the defendant applied to strike out the parts of the statement of claim that referred to Germany and France. In fact, Mr. Justice Aldous, as there was, decided that there was no threat in the letter in relation to German and French patents, and the point was therefore academic. But he nevertheless went on to deal with the issue of whether a declaration could be sought in relation to non-infringement of a German and a French patent. And he deals with that on page 7 of the bundle. Counsel for the defendant also submitted, this is, sorry, at the bottom of the page, 2 paragraphs up, counsel for the defendants also submitted that the allegation seeking a declaration in respect to the German and French patents should be struck out, as patents were strictly territorial in operation and were governed by local law and were only justiciable in the country in which the patent was granted. He referred me to the Mozambique case. In that case, the court had to consider whether there was jurisdiction to consider a question of trespass which occurred outside the jurisdiction. The court held there was no such jurisdiction to decide the case. That case has been applied since in a number of cases. Mr. Waugh also drew my attention to the decision of Mr. Justice Vinelot in the Tyburn case. Mr. Justice Vinelot, relying on 2 Australian cases, concluded that the reasoning of the rule in the Mozambique case applied to copyright just as much as it applied to other intellectual property rights, such as patents. Mr. Waugh, who appeared for the defendants, also submitted the court didn't have jurisdiction as the question of infringement of the European patents didn't appear to satisfy Rule 203 of Dicey. But that we needn't be concerned with. Let me take you now to the second paragraph on page 447 of the report, with the just about the middle of the page. Having regard to the conclusion I've already reached, there's no need for me to decide those issues of law, and I believe it would not be right for me to do so at this time. Clearly, the submissions of the defendants have considerable force, based as they are upon the considered judgment of Mr. Justice Vinelot and the established law. However, it may be necessary at some time to decide whether that is so plainly right as to prevent persons from arguing the point. Certainly, that was the view of Mr. Justice Vinelot. For myself, I would not welcome the task of having to decide whether a person had infringed a foreign patent. Although patent actions appear on their face to be disputes between 2 parties, in reality they also concern the public. A finding of infringement is a finding that a monopoly granted by the state is to be enforced. The result is invariably that the public have to pay higher prices than if a monopoly didn't exist. If that be the proper result, then that result should, I believe, come about from the decision of a court situated in the state where the public have to pay the higher prices. One only has to imagine a decision of this court that the German public should pay to a British company substantial sums of money to realise the difficulties that might arise. I believe that if the local courts are responsible for enforcing and deciding questions of validity and infringement, the conclusions reached are likely to command the respect of the public. Also, a conclusion that a patent is infringed or not infringed involves in this country a decision on the validity, as in this patent no man can infringe an invalid patent. In the present case, the plaintiffs admit the validity of the patent, and there is therefore no dispute about the matter. However, it will be implicit in the judgment of this court that there has been infringement and that between the parties the patent is valid. Thus, I believe it is at least convenient that infringement, like validity, is decided in the state in which it arises. Then he goes on to say this: I also believe that it would not normally be right for the courts of this country to decide a dispute on infringement of a foreign patent in respect of acts done outside this country. Then he says, provided there is an adequate remedy in the relevant country. Mr. Justice Aldous seems to be saying that whilst in principle it is not a good idea for the English courts to be handling foreign litigation, foreign IP litigation. Nevertheless, it could be decided on a forum conveniens, or the difficulties that he adverts to can be handled by means of the forum conveniens point. Well, as I've said before, it can't.
The previous paragraph is reminiscent of the non-enforcement of foreign public law doctrine, because it's talking about monopolies and so on. And there would have been quite a respectable argument for saying that one shouldn't enforce foreign monopolies or foreign antitrust laws and so on because they reflect a public policy in the foreign country. The trouble is this past has been sold on that, particularly in the EU regulation. And that argument is really no longer available as a general principle.
For present purposes, Lord, I'm dealing with English law, not EU law. I'll come on to deal with the WUSU later. But so far as English law is concerned, in an extra-community context of...
The EU regulation, the Rome II regulation applies worldwide.
That's the point with respect that I've parked to look at later, but, over lunch. But leaving that aside, and just confining my attention, if I may, to what Mr. Justice Aldous, as he was said, it's apparent that he sees all the difficulties attendant upon enforcement of patent rights. In due course, I'll seek to extend that to copyrights too. And whilst he appreciates those difficulties, he seems to be saying that perhaps the forum conveniens test would be an appropriate way of dealing with those difficulties. And it's only in the very rare case of Mr. Ainsworth that such an action can be brought. That's what I think he's saying there. But ask oneself, or I ask rhetorically, what would Mr. Justice Aldous have said if he was asked, or if he was told, that a WUSU prevents the application of the forum conveniens test? Would he have said, oh well, forget all about the difficulties I've adverted to in those two paragraphs, we've got to be able to sue that man in this country? Or would he have said, that man in this country is a small problem compared with the problems set out above? I would submit that he would have said the position of Mr. Ainsworth in this country is a small problem compared with the major problem in the previous paragraph. Why would he have said it's a small problem? Because in the vast majority of cases, it's possible to sue somebody in this country using English law to prevent his activities. And if you can't sue him in this country to prevent his activities, in the vast majority of cases, you can sue his customers in the country where he's exporting to, the importers. It's only in the extraordinary facts of this case that the problem really arises. So in my submission, if Mr. Justice Aldous had been told about a WUSU, it is quite clear from his judgment that he would have said that the policy of the law should be to continue to apply the local action doctrine to patent actions.
Well, the underlying principle, I would have thought that he's giving expression to there is the primary consideration is providing a remedy, and normally it's not going to involve inconvenience, but in the rare case where it does, you still provide the remedy. You then say to him, well, the only way you can provide the remedy is in this jurisdiction. Why wouldn't that apply to every case?
But because, Lord, he makes it quite clear in the previous paragraph that there are serious policy considerations against providing that remedy in this country, in the general run of cases. There are exceptional cases where, for some reason or other, somebody can't be sued. Now,
well, the exception is because you can't get the remedy anywhere else.
Yes, but, Lord, there is a third point I should have made in connection with that. Whilst it is a point that in many cases can be dealt with by either suing that person in this jurisdiction on the local right, or by suing his customers where the infringement, or where the right exists, which covers an awful lot of cases, the fact is that for centuries the problem has existed of people outside a jurisdiction manufacturing goods which infringe IP rights in other jurisdictions, and those goods find their way into that other jurisdiction. This is an entirely familiar problem in the law of IP. And in all those cases, unless the defendant manufacturer in the foreign territory happens to have intruded his toe into the state where the right exists, there is, for practical purposes, no remedy against that person who is the primary cause of the claimant's problems. It's an entirely familiar problem, as I say. So Mr. Ainsworth is only different from the normal run of cases in that he happened to stick his toe into the United States by allowing advertisements to appear in the American newspapers. And if he did himself import into the United States, by importing into the United States. But your lordships have had pressed upon you the undesirability, or so it is said, of leaving somebody without a remedy. But that is a problem or a consequence which is inherent in the local action doctrine. It was actually referred to, it was why Lord Mansfield, in those two cases which are referred to in all the local action cases, Lord Mansfield was anxious to find a remedy in two cases he heard, where serious trespasses had occurred in territories where there was no other legislature. Somebody had been expelled from some land in Lapland or somewhere, and another case where the Royal Navy had evicted somebody from somewhere. And in both cases, Lord Mansfield, while accepting the existence of the local action doctrine, said that because there are no local courts, I'm going to make an exception to the normal rule, and in this case, the defendants against whom there would be no other remedy can be sued in England. And it was those two cases that were which were said to have been wrongly decided. They were referred to in the American case, I showed you Livingston and Jefferson, I showed your lordship too. It is inherent in the local action rule. The local action rule may, in the context of land, be somewhat old-fashioned. As we shall see, it has a real and important continuing significance in the realms of IP. It is, I accept, an inevitable consequence of the local action rule that there will be people who cannot be sued abroad. But that's what the local action rule necessarily implies. But I say, although it necessarily implies it, it is not, in fact, so serious a consequence as to justify the much more serious consequences of blowing away the doctrine altogether. The serious consequences that Lord Justice Aldous adverted to in that passage, and which Mr. Justice Laddie deals with in the next case I'm going to take your lordships to, Coin Controls and Suzo at tab 15 in this bundle. Another patent case. Looking at the head note, the plaintiff, owner of 3 identical European patents, the United Kingdom, Germany and Spain, and pausing a note that they were identical European patents, in respect of coin dispensing device, sought relief in respect of infringements in all 3 countries against 4 defendants. Defendants made an application to remove from the proceedings all the defence of the first offence and strike out from the statement of claim all assertions relating to the infringements by any of the defendants of the German or Spanish patents. And then your lordships will see the second paragraph in the holdings. And if I could take your lordships on to page 9 of the bundle. First complete or second complete paragraph. The principle at the top of page 9, the principles which applied to land in the Mozambique case apply equally well to attempt to litigate foreign intellectual property rights in English courts. Those rights give rise to monopolies or quasi-monopolies, which are strictly territorial in nature. In the case of patents, historically their purpose was to encourage and protect local industry. So courts, following the common law tradition, have declined to entertain actions concerned with the enforcement of foreign intellectual property rights. See Potter and Tyburn Productions. And then he quotes Mr. Justice Aldous, the passage I've already taken your lordships to. But before I move on, can I emphasise two things about that passage? He's talking about intellectual property rights in general. He's not limiting what he says to the validity of intellectual property rights. When he refers to monopolies, he's referring to patents. When he's talking about quasi-monopolies, he's talking about copyrights. Copyright, at least I would submit that's what he's saying. Copyrights are not monopolies for the reasons my learned friend has given. They are, however, quasi-monopolies, particularly when you're dealing with functional products, or products which have a function, in that, for practical purposes, they do foreclose a potential area of competition. That's why the British Copyright Act cuts down the length of, or the term of products which have a functional significance, as we've been through in some detail. When he refers to quasi-monopolies, in my submission, he must be referring to copyrights. And he rightly says that they are strictly territorial in nature. And then he refers to Tyburn, which is indeed a copyright case, which we'll be looking at in a moment. Then, at the bottom, he deals with the double actionability point. Mr. Silverleaf said that the Mozambique rule was to be regarded as part of the double actionability rule, as evidenced by the fact that Lord Herschel referred to Phillips and Eyre. As a result, he said that this rule was abrogated by Section 10 of the Act of 1995. I do not agree. The Mozambique rule has nothing to do with double actionability. It is a principle of public policy based on the undesirability of our courts adjudicating on issues which are essentially foreign and local. And of course, the word local ties back to what he said above about these monopolies being strictly territorial in nature. And then he goes on to say on the next page in the middle, if the Mozambique rule has been destroyed or limited in relation to patent or similar rights, that must be as a result of our adherence to the Brussels Convention, not because of the acts of 1982 and 1995. It follows that in the absence of any change in our law brought about by the Convention, the three foreign claims are not justiciable here, and I would order them to be struck out of the plaintiff's proceedings. And when he says justiciable, I would submit he means there is no jurisdiction to hear them. If the word justiciable in that context means anything else, well, I don't think it does. He's saying they are claims over which the court has no jurisdiction. And the reason the court does have no jurisdiction is the local action rule. Well, that is, I would submit, a very strong authority from a judge who knew what he was talking about in the context of IP law. It brings me to the Ove Arup case, which is at tab 26 in this bundle, which was decided by a court which did not consist of IP lawyers. And in my submission, it approached the whole topic on a wrong basis. Let me start with why I say that is so by taking your lordships to page 24. The passage my learned friend relied heavily upon in this case is in the middle of page 24, where the court said, we think that the approach to the House of Lords in the Mozambique case was in substance the same as that of Lord Esher in the Court of Appeal. He had identified the question in a passage to which we've already referred as whether, and perhaps I should turn the Lordship's back to that, but he referred to it at page 19, where you'll see that halfway down. Third of the way down. Lord Esher, the Master of the Rolls, in a dissenting judgment which was expressly approved by Lord Halsbury in the House of Lords, much relied upon in Broken in Potter. And then he quotes it again, going back to page 24. Whether in regard to an act of trespass done to land situated outside its territory, there's evidence to justify the inference that the Comity of Nations, the jurisdiction to determine the rights, such an act has been allowed to other nations in this country and has been accepted by this country. In other words, he says, it is entirely a question to be determined according to the Comity of Nations, which approximates perhaps to the Sovereign Acts point. But, my Lords, firstly, Lord Halsbury did not actually, in his judgment, which is at tab 11, page 17, expressly endorse every way in which Lord Esher had put his judgment. All he said, unless I've missed something, at the end on page 17 is, I'm therefore of the opinion that the judgment of Mr. Justice Wright and of the Master of the Rolls was correct, and I think therefore that the judgment of the Court of Appeal on this point should be reversed. It's not exactly a ringing endorsement of every sentiment expressed by Lord Esher. But more to the point, or perhaps more significantly, there is what Lord Fraser said. I already took your Lordships to the quote in the Hesperides case, where Lord Fraser said that the basis of the House of Lords judgment in Mozambique was the local transitory point. So, the Court of Appeal started, I would submit, with the idea in their head that the whole doctrine was based on some idea of comity, which itself required some evidence of worldwide consensus before any application of the rule could be got off the ground. And moving on in the decision, as your Lordships have already been told, this was, in fact, a case about the Convention. It wasn't actually about the, in principle, it wasn't about the question of whether English law would allow an American copyright action to be sued on in England. My learned friend, I think, said that that was a necessary condition for the Court of Appeal to accept the in personam jurisdiction created now by Article 2. But if your Lordships go to what was said by them at the end of what they said about Mr. Justice Weinlaw's decision in Tyburn, which is on page 30, I'll be looking in more detail at what they said about Tyburn in a moment. They dealt quite briefly with the Tyburn case, and they said, we do not find it necessary to decide whether Mr. Justice Weinlaw was correct to take the view, if he did, that an action for alleged infringement of a foreign act copyright by acts done outside the United Kingdom in a state not party to the Brussels Convention, in a case where no question is the validity or registration of the right in issue, was not justiciable in an English court. So the fundamental question before your Lordships was not decided in Ove Arab. They decided the whole case in the context of the Convention, and if and insofar they felt it necessary to decide as a separate issue whether they'd got subject matter jurisdiction, they decided it as Mr. Justice Lloyd below had decided it, on the basis that there wouldn't be much point in being given in personam jurisdiction under the Convention if you didn't also have subject matter jurisdiction. Now, that may be a point against me when we come to Owusu. It may not be. But so far as this case was concerned, insofar as the Court of Appeal considered any question of subject matter jurisdiction, it did not decide and expressly refrained from deciding whether Mr. Justice Vinelott's view was correct. Can I take your lordships to the Tyburn case? Your lordships have already seen references with evident approval from Mr. Justice Laddie, and if I remember rightly, also Mr. Justice Aldous to the Tyburn case. A copyright case. That's bundle 2, tab 31. The case, as your lordships have already heard, was an application for a declaration about the state of copyright law in America. And it is perhaps not surprising that Mr. Justice Vinelott thought it inappropriate to grant such a declaration anyway. But if your lordships would turn to page 5, it is evident that he saw, or what he saw was the main point in the case. 2/5 of the way up the page from the bottom of page 5. The central issue in this case is whether the distinction between transitory and local actions, which was considered by the House of Lords in the Mozambique case, was fundamental to that decision, and if it was, whether an action raising questions as to the validity or infringement of patent rights, copyrights, rights of trademark and other intellectual property rights are properly to be considered actions of a local nature, or whether that distinction was, as it were, an historical prologue setting out the basis of a narrower rule that the English courts will not entertain proceedings raising questions as to the title to or damages for trespass to land. So he sets out very clearly the issues which might be said to arise in this case. He was very much aware of the distinction between infringement and validity. He was very much aware of the potential analogy between copyrights and patents, and it is evident that he saw no principled distinction between the different categories of intellectual property rights. And then he discussed, and again, it's significant that he saw the Mozambique case as being based on the local rights point. And he considers the local right, the Mozambique case. On the next page, where page 82 of the report starts.
Shall we come back to this at 2 o'clock?
Oh, yes.